Give me just a second, Mr. Pro.
Right away, you can feel the courtroom energy, casual tone, but don't be fooled. Moments like this often signal a hearing that looks routine but can turn serious fast. And trust me, probation hearings are where small mistakes suddenly become big consequences.
So, you were late this morning, Mr. Gross. Okay. So, probation sent me over an administrative hearing showing that you had failed to report twice in August and then again in December, that you weren't working and giving proof of that you're behind in your community service, that you didn't take the defensive driving course yet, that you did not complete the psychological evaluation so that we could figure out what, if any, tools.
This is what lawyers call a stacked violation record. Missing meetings, unfinished programs, no employment proof. Each one alone is a warning, but together they tell the judge a pattern. And courts care less about excuses and more about compliance.
So we could figure out what, if anything, you need to be successful on probation. So let's start there, because I think that's probably one of the most important parts of it, is why haven't you done that evaluation yet?
Here's a tough reality about probation. Real-life problems don't pause legal obligations. Judges may sympathize personally, but legally, probation is viewed as an opportunity, and failing requirements can look like refusing help rather than struggling. Here's a tough reality about probation. Real-life problems don't pause legal obligations. Judges may sympathize personally, but legally, probation is viewed as an opportunity, and failing requirements can look like refusing help rather than struggling.
You're not going to be able to help her if you're in prison, are you? Okay, so you have to do your probation no matter what. That's not an excuse, and I won't take that as an excuse. You can make an appointment. You're going to get that evaluation done within the next 2 weeks, or I'm asking them to file a motion to revoke your probation. It's that simple.
That right there is an ultimatum. In courtroom language, this is the judge giving a final lifeline. 2 weeks isn't just a deadline. It's essentially the court saying, show effort now, or we move toward incarceration.
2 weeks. 2 weeks to get the evaluation done. If you're not working, you should be doing community service every single week.
How many months or days have you been going to county for previous charges?
It's not.
Whoa, did you catch that shift? Instead of fixing probation, he's asking about jail time. Judges often interpret this as surrendering the opportunity probation provides. And psychologically, that can change how the court views motivation and risk moving forward.
A county case, it's a felony. So here's what you're charged with: the state jail felony offense of evading arrest or detention with previous convictions. And so if you don't want to be on probation, then they can file a motion to revoke. They have enough here to revoke your probation. But why wouldn't you want to just, I mean, you don't want to go to state jail prison, do you?
It's too much.
But you're going to be away from your family for some amount of time if you get revoked. I don't know. We're not here I don't do the negotiations. So if you want to have your probation revoked, what would happen is a motion would be filed. There would be a warrant for your arrest. You would get in custody. We would appoint you a lawyer. That lawyer would talk to Ms. Malfino. They would discuss what your violations are, what they think might be a fair punishment. We would come to court. If I think it's a fair punishment and agree with him, I would give it to you, and you would go do whatever time that is. It's not going to, I would assume it wouldn't be the whole 2 years, but I don't know right now. I don't remember what your criminal history was, other than I know that. Hold on a second.
Definitely not.
Yeah, so, I mean, you know what a 1244 is? Okay, well, what a 1244 is, a lot of people think if they get a state jail prison time, There is a way that you can do county jail time in some cases on that, and what she's saying is it's not going to be county jail time. It will be some amount of state jail time. So you don't want to get the help with probation? You want to...
It's too much, man.
All right, well, I don't know that. That I'd let you go today then. Have there been any issues with drug use? Any no positives? How quickly can y'all get that done? What's your position with regard to where we stand right now? I mean, we've got violations, obviously. If he doesn't want to go do those things,
Surely she can take advantage of the help and try to get a judge.
I know.
It seems a shame.
I don't disagree.
It's not for me to decide. I know this, we're really willing to work with him. I know what he says, it's a lot. I know there are specialized cases that maybe help him get on track. I know that's what we're gonna work for.
You don't want to think about it for...
How many months or days?
I don't know. That's the thing. I just told you. We just went through that. All right, then at this time, what I'm going to do, unfortunately, Mr. Gross, is because of those violations of your probation that you already have, at this point, I'm going to order as a condition of probation, because you're still on probation, that you serve 20 days upfront time. You'll go into custody today. That'll give the state time to get that motion to revoke filed. You'll get credit for the time that you're sitting, but I'm not going to let you go today and possibly do something else that you're not supposed to do while you're on probation. So you can go back with the bailiff.
And this is the consequence phase. Notice the judge didn't revoke probation immediately. Instead, he imposed short-term custody. That's a strategic move. Protect public safety, pressure compliance, and give the system time to decide whether probation can still work.